Good afternoon. Welcome to the Analyst. Today we'll be taking up 5 newspaper articles from the Hindu and the Indian Express and discussing them. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. The first article that we'll be taking up today is related to death penalty. As the Parliamentary Standing Committee on Home Affairs was expected to make a recommendation regarding the abolition of death penalty in India, but it left the matter for the government to consider. The second article is related to the British policy of sending asylum seekers to Rwanda. So we'll be talking about asylum, refugees, and the need for a refugee law in India. The third article is related to Consumer Protection Authority. As the Central Consumer Protection Authority has been probing some IAS coaching institutes for their false and misleading advertisements. The fourth article is related to the proposed new criminal code, that is Bharatiya Nagarik Suraksha Sanhita, which is supposed to replace the Criminal Procedure Code. And the final article is related to Birsa Munda, a tribal icon. The Prime Minister recently visited the birthplace of Birsa Munda. Now, the first article is related to death penalty. As the Parliamentary Committee has not made a recommendation to abolish the death penalty and it has left the matter for the government to decide. This is important in GS2 in the topic Important Aspects of Governance. First, let's talk about the arguments against death penalty. The philosophy of Indian criminal jurisprudence is based upon reformative justice, not retributive justice. When we inflict death penalty or capital punishment upon an accused, there is little chance of reform left. This is a kind of punishment which is irreversible. It is a kind of retributive justice also, if we say so, because it's like inflicting revenge upon the accused and giving him little chance for reform. And in a civilized society, it may even be considered as amounting to murder. For example, the society taking away life of an individual, and it becomes like a typical antithesis to one's right to life also, the right to life which is enshrined under Article 21 of the Constitution, of our Constitution. And when we look at it from the philosophical point of view, Immanuel Kant says that human beings, they should be treated as an end in themselves. Human beings should not be treated as a means to another end. If we say that by inflicting death penalty upon an accused, we are going to create deterrence or we are going to achieve a crime-free society, that is our so-called end. But here we are using human beings as a means. So it can be termed as unethical or immoral from the Kantian perspective also. Or we can look at the views of Albert Camus, who says that this is like upsetting the very solidarity, because human beings, we have a very basic solidarity, the solidarity against death, and inflicting capital punishment, that upsets that basic human solidarity against death also, and it amounts to like a crude arithmetic of taking revenge here. If we look at the legislative intent, when we look at section 354 subclause 3 of the Criminal Procedure Code, there also the legislature intended the judiciary not to resort to the capital punishment in the very first go, etc. For example, if the judge has a choice to choose between death penalty or awarding the sentence of life imprisonment, if he is choosing inflicting death penalty, then special reasons have to be recorded when death penalty is awarded to an accused. Therefore, even the judiciary is also fallible. There can be mistakes on the part of judiciary also, and the punishment is the one which is irreversible. Although there are provisions for appeals, even mercy petitions can be filed in front of president, etc. But still there are chances of mistakes. And we as a society will be having a moral high ground if we abolish the death penalty. For example, internationally looking also, when we look at various international organizations like Amnesty International, they are all vocal opponents of death penalty. So we can consider abolishing that too. Plus, there is one myopic consideration also. Sometimes from a utilitarian point of view, it is said that inflicting death penalty will be cost effective, will be ending up saving money for the exchequer, saving money for the government. But there also it is flawed sometimes, because lengthy judicial processes, appeals, and then mercy petitions, etc., they are also causing immense cost to the exchequer. Now, let us look at some judicial pronouncements regarding the death penalty in India. First, there have been varied judicial opinions. They have evolved over a series of cases. We'll be discussing a few. For example, in Jagmohan Singh versus the state of Uttar Pradesh, the court observed that the death penalty, it is constitutionally valid. It does not violate Articles 14, 19 and 21, on the basis of which the sentence of death penalty was challenged in the present case. The court also observed that this is as per the procedure established by law, as there were arguments that this is going against the law which is contained within CRPC, which deals only with respect to investigation, trial, etc., not the manner in which death penalty is to be inflicted. But the court observed that this is as per the procedure established by law, as a judge makes a choice between the death penalty and the life imprisonment based upon the circumstances and facts of the case and the nature of the crime. Therefore, it is constitutionally valid. When we look at the case Rajendra Prasad versus state of Uttar Pradesh, again, here the court observed that it is violative of Articles 14, 19 and 21. And Justice Krishna here observed that in the extreme cases only it can be awarded, and two things have to be followed. One, the special reason has to be recorded. It is a must whenever a death penalty is awarded, and it can be awarded only in extraordinary circumstances. Now, going further, these principles were further initiated in the future cases. For example, in Bachchan Singh versus state of Punjab, in this case, the court overruled the Rajendra Prasad judgment, where it was held that in the Rajendra Prasad judgment, it was held that the death penalty is violative of Articles 14, 19 and 21. In Bachchan Singh case, the court held that it does not violate Article 14, 19 and 21. It can be termed as reasonable, fair, just and reasonable as an alternative punishment for murder. And here the court enunciated the principle of rarest of rare cases, that is, the death penalty can be awarded only in the rarest of rare cases, and the court also observed there has to be some mitigating and aggravating factors which have to be considered when the court awards the death penalty. The mitigating factors are those which are in favor of the accused, that he should not be awarded death penalty. For example, maybe the mental and emotional state of the accused at the time, or age of the accused, etc., considering which death penalty may not be awarded. And the aggravating factors are those factors or circumstances in the present case where the condition of the victim should also be taken care of, and where the factors are going against the accused. For example, maybe the age of the victim or the nature of the crime, etc. Going further, in Machi Singh versus state of Punjab, the court even categorized the cases. The court gave 5 categories based on which a case can be termed as the rarest of the rare case and death penalty can be awarded. Some principles were enunciated here. For example, the court considered that the manner of commission of murder has to be taken into account. If the manner of commission of murder is extremely brutal and it has to evoke indignation of the society, it will shake the conscience of the society, then it can be considered as the rarest of a rare case. The motive also has to be taken into account. If the motive evinces depravity or meanness, for example, maybe a hired assassin, a cold-blooded murder, etc., then it can be termed as a rarest of rare case. If the case is one which is having a nature of anti-social crime or a socially abhorrent nature, for example, where the victim is belonging to a minority or a scheduled caste, etc., which can trigger social outrage also. Or the magnitude of crime can also be considered. For example, maybe the murder of multiple members of a family or the personality of victim. Such factors can be taken into account when determining whether the case belongs to the rarest of the rare category or not. In Dina versus Union of India case, it was challenged whether hanging by rope, it is just fair and reasonable, whether it is going against Articles 14, 19 and 21. Here the court observed that this is reasonable. In Mithu versus state of Punjab, in this case the court held the section 303 of the Indian Penal Code to be unconstitutional. What does section 303 of IPC say? It says that if a convict who is undergoing life imprisonment for another crime, if he commits murder, then he has to be awarded death penalty. This section was leaving little scope for judicial discretion The judge could not choose whether he can be awarded life imprisonment or death penalty because that discretion was taken away. Therefore, the mitigating, aggravating circumstances, etc., the facts and circumstances of any case could not be taken into account. Hence, this section was termed as unconstitutional, and the court held that for any crime, death penalty cannot be the sole punishment which can be inflicted. Some judicial discretion should be allowed. Now, the second article is related to the UK policy of sending asylum seekers to Rwanda. The United Kingdom Supreme Court has declared the scheme of the British government to be unlawful. This is important in GS2, effects of policies and politics of various countries and its impacts on Indian interests and Indian diaspora. Now let's talk about the UK policy first before talking about refugees, asylum seekers, the status in India, need for a refugee law in India, and the Refugee Policy Convention and the Protocol of 1970. First, let's talk about the UK policy. Now, in UK, it is facing increasing number of illegal immigrants, for example, through the English Channel. They cross the English Channel using small boats, etc. The UK PM Rishi Sunak even called for stopping of the so-called boats because in 2022 almost 45% of the asylum seekers applications were coming from the people who had crossed the English Channel through the so-called small boats, etc. Now, why UK is going for such a policy? Because the Conservative Party has always had an anti-immigrant stance. It has always taken naturally an anti-immigrant policy, and these sentiments even fueled Brexit also. This was one of the factors which contributed to Brexit, and they want to protect the jobs in UK. And such protectionist policies have led to such sentiments and such steps. There have been some recent reasons also for such a policy. For example, due to pandemic, the number of immigrants wanting to go to UK, they have increased. Likewise, economic distress in developing countries, that has also fueled migration. And the displacement due to the conditions in some countries, for example, Afghanistan, Iran, Iraq, etc., that has also been contributing to increasing number of people wanting to go to Western Europe, particularly UK, and the war in Russia-Ukraine region has also contributed. Now, what is the policy of UK? The policy is they want to detain the person who have illegally crossed the English Channel on boats, etc., and they want to detain them and then deport them. They want to remove them to third countries, the so-called safe third countries, which are safe for the illegal immigrants, where they will not be persecuted as per UK policy. So they have treated certain countries as safe third countries. Even India has been termed as a safe third country by UK recently. One of them is Rwanda. And even children can also be detained. Now they are also denying the right to bail and even judicial review for 28 days after detention. And the policy blocks the returning of such people who have tried to illegally immigrate to UK. In future also, if they apply for British citizenship, they will be denied. And it wants to put a cap on the number of refugees who will be accepted from countries like Afghanistan and Ukraine, even those who are coming through the legal routes. Now, what is the criticism for this? One is the principle of non-refoulement. What does the principle of non-refoulement say? As per this, if a person who flees his original country or the country of origin, if he is fearing persecution in his home country, then he should not be deported by the country to which he has immigrated to his home country where he is fearing persecution. And they are denied a right to fair hearing also, because as per the new policy, there will be no right to bail and no judicial review also for 28 days. And the UNHCR, the United Nations Human Rights Commission, has also criticized the policy of UK of deporting the people to third countries. Now let's talk about some basics also regarding refugees, asylum seekers and migrants. Refugees are those people who have fled their country of origin, their home country, because they were fearing persecution. That persecution fear may be based upon race, religion, nationality, or maybe even holding certain political opinions, etc. And their own government could not and they will not protect them from those dangers, from the fears of the persecution. And they have a right to international protection. There is a difference between refugees and asylum seekers. Asylum seekers are those who have applied for getting that refugee status, but their application is still under consideration. It has not been evaluated. They are claiming to be refugee, but they have not yet been awarded that status. And every refugee is initially an asylum seeker. Therefore, that right of international protection that is there with the refugees, not the asylum seekers. Whereas when we talk about migrant, there is no internationally accepted legal definition for migrant. Migrant can be any person who migrates to another country, maybe for work, maybe for family or personal reasons, etc. Now let's talk about the UN Refugee Convention of 1951. This convention defines refugees. That is the persons who are migrating from one country to another, fleeing persecution, fearing persecution in their home country. It also defines the rights of the refugees and responsibilities of the nation which has granted the refugee status. It also defines the people who do not qualify as refugees. For example, war criminals, they cannot be termed as refugees. And the convention is based upon the core principle. The core principle is non-refoulement. That is, person who is fearing persecution in the home country should not be sent back, should not be deported back where his personal safety is in danger. This convention of 1951, it was initially limited to protecting European refugees after the World War II. But the 1967 protocol has removed these geographical as well as temporal limitations, and it is applicable to all the refugees irrespective of the geographical divides or timelines. Now, India is not a signatory to either the Convention of 51 or the Protocol of 1967. Why? Because in South Asia there are porous borders, and any conflict in the South Asian region, it can trigger a mass movement of people across borders, and it will be very difficult to keep a check on those porous borders. For example, Indian borders with Bangladesh. Then it will also put a strain on the local infrastructure and resources. It will even upset the demographic balance in India. It might even cause internal security concerns and fueling terrorism, separatism, etc. also. Now, what is the status in India as of now? When we look at the number of refugees, as of 2020, more than 2.5 lakh refugees are presently in India. Mostly they are Tibetans or Sri Lankan Tamils. And when we talk about the dealing of refugees, we deal with them on a case-to-case basis. There is no single refugee law in India, but it is needed. There are arguments for a refugee law in India. For example, there is an absence of specific law, and the refugees, they are dealt with under various acts. For example, the Passports Act, Extradition Act, Foreigners Act, etc. And because of this specific law absence, there is an unequal treatment of various refugees. For example, the Tibetan refugees, they are rather well received as compared to the refugees who come into India from Myanmar. And there is an intermixing of refugees and migrant also because of that absence of clarity. There is no distinction in law, distinction between a foreigner voluntarily coming to India and staying here and a refugee who is fleeing persecution in his home country. And the Citizenship Amendment Act of 2019, that also deals with the refugee status. It awards citizenship status only for religious persecution, only on the ground of religious persecution. Therefore, the issue has to be dealt with like a human rights issue also, considering the geopolitical, political, economic and internal security dimension holistically. What has been the Supreme Court's stand on refugees? The Supreme Court has interpreted the word person, which is contained under Article 21, to mean both citizens as well as non-citizens. In the case Khudiram Chakma versus State of Arunachal Pradesh, here the court observed that Article 21, the right to life and liberty, it does not include the right to reside and settle, which is contained under Article 19, subclause 1, subclause E, which contains the right to residence, etc., which is available only to citizens. And in National Human Rights Commission versus State of Arunachal Pradesh, here again the court observed that the people who are illegal immigrants here, they cannot be forcibly evicted by organized groups, that is non-government organized groups. Like here in this case the Chakmas, they were forcibly being evicted by some groups like All Arunachal Pradesh Students Union, etc. And the court observed that due process of law has to be followed and there has to be a competent authority which has to be constituted as per law by the parliament to decide upon the cases. Now coming on to the third article, it is related to Consumer Protection Act. The context behind it is that the Central Consumer Protection Authority is probing 20 IAS coaching institutes for making misleading claims in their advertisements and for unfair trade practices. This is important in both GS3 and GS2. In GS3 in Indian economy and GS2 in governance. Now let's talk about the provisions of Consumer Protection Act 2019. It defines the term consumer. The consumer is any person who avails any services or procures any goods for any consideration. And he is not a reseller. This can be done both offline as well as online. There are certain rights of consumers which have to be protected as per the Consumer Protection Act 2019. This Act of 2019 replaces the earlier Act of 1986 and now it is more holistic and establishes an authority and protects certain rights. Now, 6 rights are to be protected. For example, the right to safety, right to be heard, right to seek grievance redressal, etc. And some of them include, for example, when we talk about right to safety, it includes the right to safety against goods or services which may be hazardous to life and property. Right to be informed regarding the quality, quantity, standard of goods or services and the prices, etc. And right to get those goods or services at competitive prices, and right to seek redressal against unfair and restrictive trade practices. Now, a Central Consumer Protection Authority has also been established, which was not there in the earlier Act of 1986. What does this Consumer Protection Authority do? It enforces the various rights and takes action when the rights of consumers are violated. It regulates and it has even an investigation wing also, which is headed by a Director General. What are the functions for this? It inquires into violations and it launches prosecution whenever there is a violation by any seller, launches prosecution at the various forums. It passes orders to recall or withdraw any goods or services and orders regarding reimbursement in case there is any damage which is inflicted upon the consumer and discontinuation of the unfair trade practices. The Central Consumer Protection Authority also issues directions to discontinue a false or misleading advertisement and it can even impose penalties. And it can issue safety notices to consumers against unsafe goods and services. Now, what are the penalties for false and misleading advertisement? As is the case here, a penalty of up to rupees 10 lakh or an imprisonment of up to 2 years can be inflicted in case a seller goes for a false or misleading advertisement. This is for the first time offense. For subsequent offenses, the penalty can be increased and a penalty of up to 50 lakh rupees and imprisonment of up to 5 years can be inflicted. It even prohibits endorsing of products which are false or misleading, and that endorsing can be prohibited for up to 1 year. And the Consumer Dispute Redressal Commission is also established at various levels. It is established at district, state and national levels. The appeals are filed in the Supreme Court finally, and the complaint can be filed in front of the Redressal Commission for restrictive and unfair trade practices in case any defective good is received or for overcharging of prices or hazardous goods, hazardous to life and property, etc. And the jurisdiction for the Consumer Dispute Redressal Commission, the pecuniary jurisdiction for the district level CDRC is up to 1 crore. that is the value of goods and services which are received by the consumer, they can be less than rupees 1 crore. And for the State Consumer Dispute Redressal Commission, it can be up to 10 crores. Above that amount, if any goods or services value is received by the consumer, it is filed in the National CDRC. It also talks about the product liability. What is product liability? It means compensating the consumer for any harm or injury which is caused by a defective goods or services. That concept is also here. Then the rules on e-commerce and unfair trade practices, they are notified by the government under the Act. These rules are mandatory, they are not advisory. As per this, information has to be given to the consumers by the e-commerce retailers, etc. Information regarding the return policy, refund, modes of payment, etc. And whenever a complaint is received from a consumer, it has to be acknowledged within 48 hours. The complaint has to be redressed within 30 days, and a consumer grievance redressal officer also has to be appointed. Then there has to be no manipulation of prices to gain unreasonable profit. And the Act also prescribes the alternate dispute redressal mechanism of mediation. As per this, mediation cells are to be established under the Consumer Dispute Redressal Commissions, and if the parties agree for mediation, if a settlement is arrived upon, then no appeal shall lie for the settlement arrived out of mediation. The next article is regarding the proposed criminal code which is expected to replace the CRPC. A report was published by the Parliamentary Standing Committee on Home Affairs. The Bharatiya Nagarik Suraksha Sanhita is supposed to replace the CRPC, and the proposed new code includes more immunity to the defense personnel. We'll be talking about the key changes that it proposes to induct as compared to the old CRPC. This is important in GS2 in governance. Now, what are the key changes that the proposed code introduces? One is regarding the detention of under trials. In the earlier CRPC, the original code, if an under trial has served half of the maximum sentence that can be given for the crime that he has committed, then he must be released on his personal bond on bail, except when he has committed a crime which deserves death penalty. Now, in the present code, there will be more exceptions. For example, if he has committed a crime for which life sentence can be awarded, then he cannot be released. And if he is being tried for more than one offense, and for the first time offenders, if they have served 1/3 of the maximum sentence that can be awarded for that crime which they have committed, then also they can be released on bail. When we look at the modes of trial, it includes electronic modes also for trial, inquiries and proceedings. Even for production of evidences, even electronic evidences are also admissible in the forms of electronic devices, etc. And the medical examination of accused, that is to be conducted by a registered medical practitioner. For this, any police officer can request. Earlier, at least an SI, a sub-inspector level officer, had to request for a medical examination of the accused. Regarding the forensic investigation, now it is mandatory for offences for which the punishment is more than 7 years, and the forensic examination, it also has to be recorded through mobile phone or other electronic devices, that is audio video recording also has to be done. Earlier, the district magistrate had a power that he could prohibit the power to carry arms in case there was a threat to public order, peace, safety in the society, etc. That provision has been omitted. Now the district magistrate no more has such a power to prohibit carrying of arms. Then regarding signatures and finger impressions, earlier the judicial magistrate or metropolitan magistrate could order any person to give a specimen of handwriting or signature, etc. But that order could be given only to a person who had been arrested during investigation. No order could be given to a person who had not been arrested. Now an order can be given by the judicial magistrate or metropolitan magistrate even to a person who has not been arrested, including for finger impressions and for voice samples also. There are certain timelines also which are prescribed for various procedures during trial, etc. in the proposed code to expedite the trials. For example, the registered medical practitioner, they have to examine the rape victims, and when they are submitting the report to the investigating officer, the report has to be submitted within 7 days. The judgment has to be pronounced within 30 days after the completion of arguments. It can be extended to up to 60 days. When it comes to the information which is to be given to the victim regarding the progress of investigation, it has to be done within 90 days. The court has to frame the charges, the sessions court has to frame the charges within 60 days from the first hearing. The mercy petition has to be filed within 30 days, and if it is rejected then within 60 days in front of the president, and no appeal shall lie. It has been clarified for the mercy petition if it has been rejected by the president. The sanction for prosecution, usually the government sanction is needed for prosecuting public servants. That sanction has to be given within 120 days by the government, and no sanction will be required in case the crime which is committed is related to sexual offences or trafficking, etc. Regarding trial in the absence of the offender, if there is a proclaimed offender, then if he has absconded, then trial can be conducted in his absence also. Proclaimed offenders are those who have committed a crime which deserves a sentence of more than 10 years and they do not appear in the court when called upon. Then regarding metropolitan magistrates also, the provision has been omitted. Earlier, the state government could notify an area, a city or a town with a population of more than 1 million as a metropolitan area, and there a metropolitan magistrate could be there, but now that provision has been omitted. Let's talk about some more key provisions of the proposed code also. One is regarding the copy of FIR. A copy of the FIR has to be given to both the accused and the victim within 14 days of production of the accused, and it will be provided free of cost. A zero FIR can also be registered, that is in the domain of a police station where the crime has not been committed, and then information will be transferred to the relevant jurisdiction police station. And summary trials have been made mandatory for the offences which are petty offences or non-serious offences, and an EFIR can also be registered, and every state will designate a police officer in the police stations who will inform the family of the person who has been arrested online as well as in person. The handcuffs use has been prescribed for certain cases. For example, if the accused is a habitual or repeat offender who has escaped from custody, or he has committed some crimes, for example organized crime, terrorism, drug, illegal possession of arms, etc., or it is related to heinous crimes like murder, rape, acid attack, counterfeit currency, human trafficking, sexual offences against children, or offences against the state. There are some safeguards against the arrests also. For example, if the crime has been committed where the maximum punishment is less than 3 years, there if the person is arrested, then prior approval of at least a police officer of the rank of DSP is required, and also a DSP level police officer approval is required when a person who is arrested is more than 60 years of age. Then regarding cognizable offences where the punishment is 3 to 7 years, a police officer will usually conduct a preliminary inquiry to establish whether a clear-cut case can be made out or not. It is to be done in 14 days. And regarding detention, if any person resists, refuses or ignores or disregards the directions as given a part of the preventive directions, then he can be detained. Now the next article is related to Birsa Munda. The Prime Minister visited the birthplace of the tribal icon and launched PM Janjati Adivasi Nyay Mahabhiyan. This is important in GS1 in history, important personalities. Now, Birsa Munda was termed as Dharti Abba, that is the father of earth, because he was also responsible for the upliftment of the Mundas when they were facing a tough time. He mobilized the tribal community against British and the Dikkus. Dikkus are the Hindu landlords and money lenders, etc. He established a Birsait sect also. Why? Because the missionaries in Jharkhand, they were converting tribals to Christianity. Therefore, he proposed his own sect, and there were a lot of followers of Birsa Munda also, and he encouraged the youth to give up drinking and stop believing in witchcraft, sorcery, etc. So it was a kind of a rationalistic reform too. Now, during his time, there was a Munda rebellion also around 1900, because the British land policies, they were disrupting the traditional land system. It was based upon the community based ownership of land and the interference of the British government in the forests in terms of the Forest Acts, which started particularly from 1885 onwards, and it was needed to suit the needs of the Royal Navy of the British also, and they required railway sleepers too, for which they were acquiring forest land and cutting trees there. And the Hindu landlords and money lenders, that is the Kus, they were also taking over the land which belonged to the tribals. And the missionaries, they were criticizing their traditional culture. Therefore, there was a revolt, the Ulgulan or the Great Tumult as it is called, where the purpose was to destroy the so-called Ravan. The Ravan, they used to term both the moneylenders who were taking their lands by trapping them under debt, and the British also who were acquiring forest lands. And therefore they targeted the symbols of the Dikus and the European powers. For example, they attacked both churches as well as police stations, and they even raided the properties of the moneylenders because they were against the local moneylenders too. And this was a successful example of the calls for justice by the tribals, that is, they showed their mettle for protest, and it led to the enactment of the Chota Nagpur Tenancy Act of 1908, as per which the lands of tribals could not be easily taken over by the Dikkus, and there were safeguards which were built in by law. Thank you.